Good morning, sir. And let me ask if Jeffrey Fennessey is here. Mr. Fennessey, good morning. You will have the right to present your thoughts or your argument after we hear from counsel. I just want to make sure you're aware of that.
Okay, yes, sir.
Very good. You don't have to, but you will have the right to speak for 15 minutes. And so if you wish to sit at that table, you may, or you can stay where you are. It's wherever.
Can I yield some of my time to my wife because she's the one that prepared the briefing and everything?
All right, very good. All right. Now, is she a party? Okay, very good. All right. Thank you. All right. Do you want to reserve any time for rebuttal?
Your Honor, yes, I reserve 5 minutes. Just
5 minutes. Thank you.
Good morning, may it please the court. Josh Jenkins for the Appellant Paradigm Building Group from the Rutherford County Bar. Your Honors, we're here on two fairly narrow issues. The primary issue here is whether the trial court exceeded its authority in vacating an arbitration award, and then secondarily, if the court does agree, whether the appellant's entitled to attorney's fees for this appeal and for the underlying trial court proceedings.
And is there any dispute here, I'm assuming not, that this is governed by the Tennessee Arbitration Act as opposed to the Federal Arbitration Act?
There's not been any dispute, Your Honor. We've moved forward operating under that it is covered by the Tennessee Arbitration Act.
But I don't think the judge's decision relied on the act at all, did they?
The trial court cited to a statute and what I think was an attempt to say the arbitrator exceeded his authority, but the trial court's order actually cited to the Cotton Arbitration Act, not the actual Arbitration Act that would have governed at the time we were dealing with this, which would have been the 2022 version.
I see.
I think that's where the trial court was going with it, but it obviously is confusing when you look at that order and what the trial court actually put in. Your Honors, this arose from my client, the appellant, sought to enforce an arbitration award that was given after a 3-day in-person arbitration. The appellees buying through counsel at the time filed an objection to that petition and filed an objection to our petition to confirm, and then combined that with a petition to vacate the award. The counsel that filed this petition to vacate was not the counsel that appeared at the arbitration, but they did represent them. It was from the same firm represented them at the trial court proceedings, and argued that the basis for setting aside the arbitration was based on information, one, that the counsel didn't have firsthand information on to begin with because he wasn't participating in the arbitration. In the court, I realized our first hearing, we don't have a hearing transcript, which is why we did at the second hearing, but the court allowed counsel to kind of go into details and allege facts that took place at this arbitration from which he wasn't participating. And the court considered that, which was why there was a back and forth on the orders that were signed at the beginning, which then necessitated a second hearing, and the trial court entered her own order vacating our award.
And so we only have a transcript from that second hearing?
The second hearing, yes, Your Honor.
And who testified at that second hearing?
There wasn't one. It was really, Your Honor, that second hearing was dealing with counsel for the Fennesseys at that time and myself had submitted competing orders based on the original hearing. I believe, if I remember correctly from the record, the trial court signed my order and they objected to it, and then we basically had a hearing and the court fashioned her own order of what she thought was the correct way to move forward with vacating this award.
Are those two competing orders in the record?
They are, Your Honor.
Okay.
They are. I have them with me, but I don't have the actual page citations to those. I apologize. Your Honors, I've cited to the Arnold versus Morgan Keegan case primarily in the appellant's brief because that case discusses at length what standards should be applied by the trial courts when they're looking at whether or not to confirm an arbitration award. And those courts are to apply a deferential standard in favor of confirming an award. And there's language cited in that case that says even if a trial court was convinced that serious error took place by the arbitrator, that's not sufficient to overturn a decision rendered by an arbitrator. And so we have an extremely narrow standard of review, and obviously the Keegan case goes into it, but the idea is we want these arbitrations to be efficient. The parties here agreed to it. The appellees are the one that actually initiated the arbitration, which I find it ironic because on their petition to vacate, they tried to argue that the arbitration provision wasn't valid, even though they are the ones that actually initiated the arbitration. And so the court really, at these hearings, got into a lot of the minutia of the details and facts which should not be considered, and kind of really got to the merits of the case. I mean, the court, I recall from the bench, was voicing concern about testimony the arbitrator heard and what was he doing and why didn't he do this.
So what was the anticipated testimony of the bankers that were subpoenaed?
Your Honor, I remember this. Obviously, I took place at the arbitration, and there was I don't know, there's two bankers subpoenaed. I don't know on one of them, but one of them was present at a meeting that was at issue that was testified about at the arbitration. They had issued subpoenas. The bank had counsel, I think it was Todd Bobo out of Shelbyville, who filed an objection. And Mr. Fuller was representing the appellees at the time in the arbitration. And Mr. Fuller, myself, and the arbitrator, Mr. Keene Bartley, met and discussed this issue. And counsel for the Fennesseys decided to move forward without staying the arbitration and without taking any action in court to compel those witnesses to appear at the subpoena. That was a calculated decision. And I've referenced in my response, which is part of the record at the trial court, they did this with numerous witnesses. There were numerous other witnesses that they subpoenaed that did show up, and then they released without offering any testimony. That was a calculated trial decision. The arbitrator gave them every opportunity.
Right, but is any of that really in the record? I mean, we don't have, that's, so, we're basically just hearing two attorneys telling us what happened in the arbitration.
No, I agree, Your Honor. I understand. And so that being the case, our position is what the court was left with reviewing was the order from the arbitrator. And that order from the arbitrator, or the award from the arbitrator, does mention that they failed to come and that the witnesses from the bank failed to come and testify, and I believe it's on. It's the paragraph number 14 of the award, which is, I think it's page 207 of the trial record. That the representative of the bank was subpoenaed but refused to appear, alleging statutory grounds to dishonor the subpoena and not appear at the hearing. That's really what this award is, essentially what we have before the court. There was no court reporter at the arbitration to take a transcript that was going to be submitted. And so when we look at the award, based on what the case law is, the trial court should have looked at that award only to determine whether or not there were grounds to overturn the award, and we would submit that there wasn't any. If you read the award, the arbitrator went through fairly well detail in laying out the facts that was presented at this 3-day testimony and the basis for his award, and he denied the 10 various claims that the appellees had during the arbitration and found for my client, Paradigm Building Group. And that's what we submitted, and that really should have been the only thing before the court, is to analyze the award that was submitted. And if you look at that, I don't think that there's anything there, and that would have been before the court, to enable the trial court to determine that there was anything sufficient under the statute to set aside or to vacate this arbitration award, and then go so far as to order a rehearing. So vacate the award, but then order the witnesses for the bank to appear and for the arbitrator to hear only that issue. I think that the trial court has exceeded their authority on that issue, Your Honors. Second, if the court were to agree and to vacate the trial court's order and order the trial court to confirm this award, we've asked that Paradigm Building Group be awarded their reasonable attorney's fees and expenses on the appeal and for the proceedings under at the trial court level. And there's two bases for that. One is the underlying contract contains a prevailing party provision, and the arbitrator addressed that in his award, again stating that he denied the appellees all 10 claims in favor of my client, and that made us the prevailing party, and that also that their claims were, I believe he said, more complicated and more involved. Second, as far as the award of the attorney's fees, both sides also asked for attorney's fees in the arbitration, which under the AAA is another basis for the arbitrator can award attorney's fees when both parties are requesting that relief.
So this arbitration was conducted under the auspices of the American Arbitration Association, but that only kicked in if the parties could not agree to the arbitrator. Is that what happened here?
They filed a demand for arbitration in the AAA, Your Honor.
Oh, they did, okay.
And I'm out of time, but if I may address just your question, they did demand under the AAA, and then we did also agree on our arbitrator. So it wasn't one where the AAA selected. Mr. Fuller and I, at the time, after they filed, we did select this arbitrator to hear.
Okay.
And that's my time.
All right, thank you. We'll hear from you further on rebuttal. Karen Fennessey, I understand you're going to argue for yourself and your husband. All right. And good morning, and I'm pleased you've had the opportunity to see the arguments in the previous 3 cases where the attorneys will present the position on behalf of their clients, and
Right.
you have the right to present your position on your behalf and that of your husband, and so you've got 15 minutes. The clock will turn green
I
there.
don't know where to start here.
And when it gets down to about 1 minute, it'll turn yellow, and when your time is up, it'll turn red. All right, the floor is yours.
Okay, so like Josh Jenkins said, basically, he talks about the arbitration, okay? That's the main concern of his. But the fact of the matter is the house speaks for itself. The builder started building it. The bank, the 2 people that was on the court document of Clara Bird in Wilson County was Jonathan Harris. He was a loan officer that we did the loan with back in 2019. And he did not come out to oversee the project to make sure that his clients were protected, he was protected, and the bank was protected.
So Mr. Harris was with the bank that you got the loan from to
Farm
do-
Credit.
Okay.
Jonathan Harrison was, now they're on the court documents, Jonathan Harrison, Abby Dewig, or Dewig, I believe that's how you say it, because she's the one that signed the loan document, and she's not even a loan officer.
And so I'm trying to make sure that I understand their purpose of being at the arbitration. You were calling them because the more draws.
Well, the arbitration clause was in the contract of Paradigm. So they made up the contract. Steve Fuller was our attorney at the time with Barham Emissary. Okay, Dan was but in the construction arbitration rule book, R-10, if I'm correct, you're supposed to go to mediation if it's over $100,000, okay? And you just present everything. Everything's recorded, everything's taped. And you agree upon an arbitrator. So when I filed complaints against Steve Fuller, Dan Barham, and King Bartley, which was the arbitrator, he had stated that he never met the Fennesseys before the arbitration, didn't know nothing about the case, but did the case anyway. So everybody was subpoenaed. You had from Codes, you had Karen Murphy, you had Lori Gibson, you had Chris Richardson, you had Brian Ferris, and also Jonathan Harris and and Mr. Bobo, which was their attorney. The first day we were at arbitration, Bartley said, well, he's got a meeting, so we'll try the next day for the bank to come, because they were all subpoenaed. Well, the second day, Mr. Bartley said that he found a federal loophole that him nor his clients had to come testify. And Steve Fuller did not step in and address that issue.
And that was your attorney?
And Steve Fuller, yeah, that was that worked with Behrman Messeri, yes. Okay. And also, we were not able to tell our story. We weren't able to present all the evidence. Ken Bartley, when he was, because he's more of an experience of the house issues, and I was more experienced on the documents and all that stuff. So he started first. Ken Bartley kept interrupting him. He couldn't tell a story about the house was messed up. Okay? So, and he told him twice that he'd get him in contempt of court if he didn't stop talking. Okay? Well, and then my husband said, well, I'm trying to explain to you at the very beginning how this started and when it started happening. And so, because mid-October is when the bad workmanship started happening with the house, because he started mid-September. And according to the loan agreement, if it's bad workmanship, not built to blueprints, not built to codes, the money is to stop, everything is to cease. See, Jonathan Harrison never came out to oversee the project, or we wouldn't be sitting here right now, because they would have stopped it, right? So, so the fact of the matter is, Ken Bartley, the second day, when the attorney found a federal loophole, he should have done a recess, right? I mean, Steve should have inverted, but either way, we should have went to mediation, okay? And Steve Fuller told me that Paradigm refused to go to mediation. I said, you can't do that. It's in the construction arbitration rule book. You have to go to mediation if it's over $100,000. You can't refuse to go. So we never went to mediation. We didn't agree upon an arbitrator, like Mr. Jenkins said. We never met any arbitrators. One was picked for us.
Did your attorney agree to the arbitrator?
But we were never told what the arbitrator was going to be.
But did your attorney agree to select the arbitrator?
Not to my knowledge. He never said anything. Because the construction, because I have the construction arbitration that the Paradigm filled out, because that was in their contract. That was arbitration. So I have the contract, and then it was turned into the AAA, and they were supposed to go to arbitration, but it kept being postponed and postponed and postponed and postponed, because I have all the documents. And we didn't go when we were supposed to in 2021. We didn't go to 2022 because it kept being postponed and postponed and postponed for whatever reason. And then we went to the Messeri for the trial. What they call, I guess, get ready for a trial. And we sat down and talked to Mr. Fuller about arbitration. And the last thing he told me was, well, the only thing that would stop that would postpone this is that there's a death in the family. That was the last thing he told us when we left the lawyer's office. I was thinking, that don't sound good. So the next day, he calls us at 1 o'clock. He said, well, Ken Bartley had a death in the family. I said, oh, really? That's interesting. So we had to wait again to go to arbitration. I'm like, why did that man say that? And also, Dan Barham was the main guy. How can you overturn an arbitration and know specifics if you wasn't there? Dan Barham wasn't even present at arbitration. How can you go to a court at Wilson County and overturn an arbitration and know specifics of what the arbitrator done when you wasn't there? How does that work? And why wasn't it taped? And why wasn't it recorded? because that's what it was supposed to be done. This was all, this was all no good, because I got all the paperwork, of what happened. So, I think we need, all this was just, nobody testified that was supposed to. The house speaks for itself. The bank didn't come out Jonathan never come out to oversee the project, or it would have stopped. That's the bottom line. There is no argument here. Jonathan Harris never came out to oversee the project. It was stopped in October of 2019. Because we had representation, we went down the codes and filed a complaint because the main anchoring down to the foundation was done incorrectly. But see, the 4 codes documents were signed off, but they shouldn't have been, because the anchoring down to the foundation was wrong, the plumbing was wrong, the foundation's out of square, you can see it, and all those were passed by the codes when they shouldn't have been. So, so we had a meeting. We set up a meeting on December 30th with the bank to discuss the issues. Because see, they had draw tickets, and every so often they make a draw out of the money, right? So December 19th, because I called Louisville, I called Matt Neal, which was over, Jonathan Harris was over the banks in this area. And I said, we got a meeting. So Jonathan told me, take pictures, write all your stuff down, we'll have a meeting, and we'll work it out and move forward.
And that was the December 2019 meeting?
December 30th, yes. And so we got there, Lee Knight was there, Melanie wasn't there, which is the owner of Paradigm. So me and my husband went to sit down, and Jonathan was here, and Lee was on the other side. Lee Knight, the builder, sorry. And my husband started to tell Jonathan about the issues, right? Well, he didn't want to hear it. He said, it ain't got nothing to do with me. It's between you and the builder. I said, you what? I said, you're the loan officer. You give us a loan, right? You're supposed to protect your investment, your clients, and the bank. So we looked at Lee Knight, he said, and Lee Knight said, I'm done with it. He said, I throw my hands up. I'm done with it. I'm not doing it. I'm not messing with the house anymore. So that's when we went straight down the codes, talked to Karen Murphy, showed her the main anchoring down to the foundation. So she sent Brian Ferris out. I ain't drinking water. Can I get a drink of water? You mind?
Yes, there's a pitcher and a cup right over there.
So anyway, sorry, excuse me, thank you. So Brian Ferris, she sent Brian Ferris out. So Brian Ferris came out. He worked at the Lebanon codes at the time. So he came out with a clipboard and a pen. He started walking around. He probably wrote down, I don't know how many things. He said, listen. He said, I've been in codes department for a long time. He said he was building a house at the same time. He said, I ain't never seen a mess like this. He said, y'all need to stop immediately and hire representation. So that's what we did. We hired Mr. Robbins, Josh Robbins in Lebanon. It was JMR Law at the time. Now it's Bassick and Robbins. So we hired him. He sat on it and sat on it and sat on it and didn't do nothing. Well, my father had a heart attack in March, so I went to Florida. And in May, we had to fire him and hire Barry Messeri. May of 2021 is when we hired him. Because the other attorney sat on it, purposely sat on it. And through this whole time, the bank, everybody tried to bankrupt us, right? So to be all just swept on the road, and everybody's just scot-free. But thank goodness it didn't work out like that. And all Mr. Jenkins is worried about is arbitration. He's not worried about his clients not building houses that are not structurally sound that could kill somebody. With electrical wire that was run by the Mexicans, workers, excuse me if I said that wrong, I'm sorry. They run the electrical wire, and they charged us $8,000 for their electric company to come out to run the wire when the Mexicans ran the wire. Electricians did not run the wire. They embezzled and frauded money. The material list that matched the lumber package. There are evidence that he used our materials, basically robbed Peter to pay Paul. Okay, basically is what that boiled down to. And when he got enough money to do them other 4 houses on the 4 lots he bought from Gene Jones, he dumped it. He was done with it. He was hardly ever there. Now there's a key witness that knows exactly what happened. The builder was hardly ever there. Lee Knott was hardly ever there to oversee his workers, right? He was too worried about getting his pilot license, flying a little plane.
Well, let me ask you, your time is almost
Oh,
up.
it is, okay.
You're pleased with the trial court's decision to vacate the arbitration award, is that correct?
Well, how can you overturn an arbitration award when Dan Barham wasn't even there? How can you overturn it? And he told me that...
Mr. Jenkins is here asking us to reinstate the arbitration award. I'm trying to find out, are you in agreement with Mr. Jenkins?
No.
Okay, so you believe the trial court was correct in vacating the arbitration award?
Yeah.
Okay.
And the house speaks for itself.
I just wanted to be
And we're still
clear.
paying for a house we can't live in.
All right. Anything further? Your time's almost up. Anything else you want to close with?
Do you want,
You've only got a minute, so
y'all got minutes, you gotta talk fast.
get to the point.
We had structural engineer Michael Vines that came out and inspected the house twice and did a report on it. And he testified for over an hour and 30 minutes in arbitration and said the house was not built to blueprints and built to codes. On the foundation, the blocks are crooked. They're out of square. One of the load-bearing walls was done with a 2x6 instead of a 2x8, the seal plate. Your J bolts are not even protruding through the wood to anchor it down, and the framing is not on 16-inch centers. It's a mess. My wife has that all in that book in color right there. That you're more than welcome to look through all that and look at it. The house speaks for itself, but we're still paying $1,800, a little over $1,800 a month for a house we can't use.
And you're in agreement with the trial judge that the arbitration award should stand?
Yes, sir.
Okay, very good. All right, thank you, sir.
Thank you.
Mr. Jenkins, you've got a couple of minutes for rebuttal.
Yes, Your Honors. I don't have too much to add. A lot of, obviously, what was argued by the appellees is not in the record and not before the court. I think that it was clear from Ms. Fennessey, they talked about all of the people, though, that testified at this arbitration. Their testimony lasted about almost 2 of the 3 days of this testimony. Mr. Michael Vines testified at length. The codes inspector, I just did want to note, Mr. Ferris actually testified on our behalf. I subpoenaed him and have Mr. Ferris testify on behalf of Paradigm at the arbitration. And I think if you look at the award that Mr. Bartley prepared and analyze that in light of the things that Ms. Fennessey was just talking about, you can see that he addressed all of these items that she was concerned about. Really, the only thing that the trial court looked at was the single issue of the bank individuals failing to appear. And Ms. Fennessey just echoed what I had said earlier. They were represented by counsel, they objected to it, and then their attorney decided to move forward with trial. And what I believe why that was the case is that this was not a matter that had been previously filed in the trial court and then stayed for arbitration. And so, you know, we deal with this when we deal with arbitrations. What's the proper process and how much authority does an arbitrator have? The proper process is probably initiating something in the trial court that the court can then enforce a subpoena to make them appear. Nobody wanted to do that because we're finally at the arbitration table. So I would just submit to the court that the trial court did exceed its authority. If we take the arbitration award that was prepared and look at it and apply the deferential standard that's set forth by the state of Tennessee, I think that the trial court erred in vacating. And if the court disagrees, I still think that there are issues with the order vacating the arbitration award, because it says, well, we don't need to rehear all three. The whole award's vacated, but the arbitrator doesn't have to rehear all 3 days. We only need to hear this issue, but the only testimony is going to be the bank individuals. So it doesn't even work procedurally in my mind if we were to follow the order that the trial court entered vacating. And so for all of these reasons, I would submit that the trial court's order vacating the arbitration award should be reversed, that the arbitration award should be affirmed, and that Paradigm should be entitled to their attorney's fees for the appeal and for the trial court proceedings.
Let me ask you one question before you go.
Yes, Judge.
There was some reference to commercial arbitration award rules, and the arbitrator cited the construction
Yes, Your Honor.
rules. Was this governed by the construction rules?
It was, Your Honor.
And what happened on the R10 mediation?
So at the very beginning, we have a pre-hearing call with the arbitrator. One of those items that gets discussed is, do we think mediation is going to be fruitful? Because if I recall correctly, under the rules, if the parties agree to skip mediation or decide that it's not going to be fruitful.
A party can opt out.
And
So did Paradigm opt out? Is that
we
what
did,
happened?
and frankly, Mr. Fuller agreed that the parties were so diametrically opposed, the best thing to do would be to get this to arbitration, that it was just going to be a waste of attorney's fees and and mediator's fees by going to arbitration.
All right,
That's all I
thank
have.
you.
Thank
Mr. Jenkins and Ms. Fennessey for your arguments. We'll take this matter under advisement. That concludes the morning docket.